Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Here, we bridge the gap between technology and the law, bringing you the forefront of electronic discovery. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery. With over 20 years at the junction of law and technology, I'm excited to help bring together leading experts and practitioners who provide a wealth of knowledge on electronically stored information.
And my name is Brandon Mack. I'm the co-host of our podcast. And with 2 decades of eDiscovery experience myself, I'm also thrilled to be able to participate in bringing you information and education around the world of eDiscovery.
NeLI is not just about discussions. It's about education and it's about collaboration.
Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note that while we engage with some of the brightest minds in the field, the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. And welcome back to another episode of the official NeLI podcast. We're so glad to be joined in the virtual recording studio here with Paul McVoy. Paul comes to us from Repario, which we are so honored. Repario is a sponsor of the NeLI conference, and we are delighted to have Paul join us. Paul, welcome to the studio.
Thank you so much for having me and for the opportunity.
Absolutely. Paul, can you just give us a quick background on you?
Sure. I started as a legal assistant at Jones Day and ended up 10 years later as the worldwide director of eDiscovery. Then I went to a vendor that eventually became Epic Global. Then I went into Milberg and started a vendor within that law firm, and that I eventually bought with Ariana Tadler, my partner, and created Meta eDiscovery, which in 2022 was acquired by Repario.
So Brandon and I are very excited to have you join us for a lot of different reasons. And one of them happens to be, it's not just your depth and breadth that we know that you'll be able to offer us here, but also because you have really been around since really the paper-based days. And I remember when I was a first year practicing lawyer, I got shown where my office was, and I got shown a dictaphone and Redwells and lots of various different banker boxes filled with that thing called paper that we don't often see much any longer. And notwithstanding, when I was a first year associate, I still had to learn the fine art of dictating to my legal assistant. So with that being said, it's interesting. You have been around, as you once was said about yourself, that since paper still ruled the day. What has it been like in this eDiscovery industry when eDiscovery was just known as discovery? What is the most interesting thing that you have seen so far?
Gosh, the most interesting thing I think I've seen is the advent of people using a computer's brain to leverage what it can do over humans. So you mentioned paper, and I mention paper so often when I talk about this stuff because when I did my second request, we had about 1,200 boxes of paper. We had to hire a team of 9 people, 8 hours just to load the paper into a semi. And the first year that was in charge of the second request, when I worked at Jones Day, was a little paranoid about rain, even though it wasn't supposed to rain. So she sent us to Home Depot at 4 o'clock in the morning to get a tarp to put over the semi in the event it might rain before the next morning at 8 a.m. when we had to deliver it to the DOJ. You know, when paper ruled the day, my life was a lot harder than pushing a button and copying things to hard drives, even though hard drives fail and give me more white hair. But
Well, I'll say, Paul, I think that we're all probably of the same kind of generation of attorneys. You know, when I started out, my first foray into discovery as well was a banker's box dropped on my desk with a legal pad and go through these documents and record what you find here on the legal pad. You know, so I've also seen that sort of evolution of discovery from the paper days all the way through to where we are in electronic discovery now. But back then, I didn't even know that there was such a thing as electronic discovery. It was an industry that was in its infancy at best when I first started practicing. And one of the things I've noticed about your career is that you've spent time both on the law firm side of that evolution and on the service provider side of the evolution. And I'm really curious, as you've seen us grow up in eDiscovery, what do you think are the biggest differences between those two sides of the coin? And how are we progressing through gaining an understanding of technology, using technology, and really seeing eDiscovery from those two different angles?
That's a great question. No, I really haven't thought of it in quite that way, but I was fortunate. I worked at Jones Day, which is a huge firm that works mostly for corporations and defense clients. And then I went in-house at a vendor, and then I went to a primarily plaintiff's firm. And so I've gotten to see a couple different perspectives. And I think in the vendor space, we're much more open to trying new things, to leveraging new technology to differentiate ourselves as leaders. In the law firm side, on the defense side, it's more of a traditional classic kind of approach. They're not trying to forge the new way to practice law or the new way to do discovery. They're doing the tried and true. And then on the plaintiff side, you have those plaintiffs' lawyers that are trying to, because plaintiffs pay for everything that they do, they're trying to leverage computing power. They're trying to leverage anything to make their cases more efficient and to get through documents and digest them in a different way. So I think each has a very, very distinct flavor. The vendor side, I like more because of the entrepreneurial aspect of it, right? If I have an idea or if I have a thought of something that could work for the industry, I can implement it and then try and convince people to use it, right? On the law firm side, your clients, even on the defense and the plaintiff side, they pretty much dictate how the case is going to go. The vendor can really lead in a different kind of way. I mean, obviously, we listen to our clients and do what they say to do in the best way possible, but we can try new things and we can innovate in ways that you just can't do in the law firm.
Why do you think that is, Paul? And there's a lot to be gained by leveraging technology in, as we say, innovative ways, or leveraging technology in a way that can go from being inefficient to efficient, that saves money. And we all know a lot of the cliche that goes along with it, but the cliche is true. If you leverage technology and you have great advice, you can do great things. So what is, in your experience, Paul, what have the trepidations been from the law firm side?
On the law firm side, I find that they're very risk averse, right? So if you can bring them 100% surety on a new solution, they are both feet in. They want to save money just as much as anyone else, but they also don't want to risk their role with their client. And because I would say at least 70% of the time we're introduced to a client through a law firm, they're kind of putting their name in front of our name in front of their client. And if we fail, or if the technology fails, or something bad happens in court because of what their vendor has done, they take the full brunt of it. On the flip side, they also take the full benefit of it. When I was at a law firm, we would be able to save clients literally millions of dollars just because we leveraged early AI back in the days of a 10x. Do either of you remember a 10x? So when we used a 10x and we could actually really go 10 times faster on document review, everyone was astounded. The DOJ, the FTC sent over their lawyers to make sure they could really believe the numbers that we were giving them and the timeframes we were giving them. It was something that the law firms are willing to do, but they won't take risk in doing it. It's just that they won't put their name on the line for a vendor's experimentation, even though we would never put out something that wasn't 100% vetted from our end of it.
It's interesting, and I feel like that sort of adversarial nature leads to that sort of conservative view of things. You don't want to be the first one into the pool. You don't want to do things that aren't really well tested. We've all lived through the evolution of TAR in the industry, and that was one of the big ones where I think that everyone was a little afraid to be the first one to really try it and test it out. But what we ended up figuring out, at least in the world of TAR, is that a lot of that is alleviated when you communicate well. If you're communicating with the other party and you're sharing what you're doing and why you're doing it, everyone gets a little bit more comfort. No one feels like they're going to get hung out to dry, and you get to be a little bit more innovative and a little bit more, dare I say it, risk taking in how you're leveraging technology and what processes you're going through. When you think of that, again, having been on the defense side and having been on the plaintiff side, and now being in that third party side, Where do you think parties have room to be better with communicating in order to facilitate the most efficient ways to pursue their matters?
Yeah, that's a really good way of thinking about it. And I always describe my role as logistics. I don't really do anything besides making sure data gets from point A to point Z. The cases back in the day, when we were all starting, you could lose your case based on a discovery issue, right? You would not find or produce the information you had to find or produce. And maybe it was because your client didn't understand what they had to do, or maybe it was because you didn't ask the right questions, but cases were won or lost. We all have those cases that we saw dismissed after, certain discovery issues were found. But that's not the case anymore. Judges understand that this is very tough, and as data grows and becomes more complicated, judges have a lot more forgiveness for people that are trying, right? And so I always say to my clients, communicate what you're doing. We don't have to get agreement with the other side, but we do have to communicate what we're doing. And we have to do it in a defensible way. So for instance, I'm a big proponent of keywords, of search term hit reports, of null set testing, right? I feel like it's a scientific process that starts at one side, goes through, and you prove that you're right by testing your results, right? Scientific process. But some people don't believe that. They believe that they should be able to develop their own keywords, run them, and then produce the results of those hits after review. And I respect both positions as long as you're transparent about it, right? So I don't want to just get documents over the transom and just have to try and understand why they're there and why certain things are missing. That makes no sense to me. And regardless of your position, and regardless of how conservative you are with your transparency, I think you're right. Communication will cure a bunch of the woes that we have experienced or the reasons that we're in front of judges. It just, as long as all the parties are on the same page. I'm involved in a case right now where the other side does not want to do a whole bunch of exchange with keywords. They don't want to have our input on keywords, and that's fine. We've tried to get it. We've let them know we tried to get it. And if the case goes without a hitch, there's no problem. If there's a hitch because their keywords were wrong, well, then we have grounds to say, hey, we tried, it failed, and now we can kind of impose our will as opposed to giving you a choice in the matter. But it's all about risk, and you're right. Risk makes a lot of sense to take in certain circumstances, especially if you're more transparent.
There's a case, and it's probably one of my favorite cases. If such a thing could exist, I probably need a better hobby. But there is a case that's out there, and I'm going to read you the quote. And the quote goes something like this: "If there is a hell to which disputatious, uncivil, vituperative lawyers go, let it be one in which the damned are eternally locked in discovery disputes with other lawyers of equally repugnant attributes." And I love the matter. For those that are listening and they want to take a look at the case, it's Kruger versus Pelican Prod Corp. Here's the thing. That case, my favorite discovery case, was from 1989. Okay? That's when discovery really was discovery. But if you read that today, it really doesn't sound that too much different from any other eDiscovery case that's out here. And the reason why I bring this up because Brandon is asking this really good question about communication, about risk, and Paul, your answers is really right on. I wonder, really, even as technology changes, even as the data sizes increase, even as the data types continuously become more diverse, things still somewhat remain the same from an attorney's perspective, in the sense that if you don't really know what is happening, you err on the side of, I'm going to be louder and file more motions. Thus, Judge Wayne Alley's argument in the Kruger versus Pelican Prod Corp case, which is saying that basically, if you don't know what you're doing, you're probably going to cause more disruption and more traffic in the docket. How do you get to the point, Paul, where, in your experience with your clients, to get them to the point where it's okay, we're going to hold your hand through this process, and you could feel confident, and you can openly communicate, and you can collaborate, and that's not a bad thing?
I try to do that with our clients. I try to leverage my experience over time with how it goes better once they do that communication and that transparency. I mean, I'm all for a vigorous defense of your client, a vigorous prosecution of your case. And I don't think that means opening your kimono on every single issue, on every single matter. But what I do think it means is that you understand what you're doing why you're doing it and why you're asking. I agree with you that parties that don't know what they're doing tend to fight harder. And there are some parties that know what they're doing and fight harder as well, because sometimes that works. And I just try and get all of the issues onto the table. I mean, you two as lawyers know this better than anyone. You have more time at the beginning of the case than you do right before trial. You have more time to look at things, you have more time to think about things and strategize things. And I always say, let's come to agreement on all of these issues. I'm a big fan of the ESI protocol. I know it's a thing that's falling out of favor, but let's have the fight now. When we all have time to go, let's just come to an agreement on what the issues are, go to the judge, have them decide, and then we can all just move towards the case with a fully focused mind. I don't believe in the back and forth. I don't believe in the motion practice. I don't believe in all of that on issues that just don't get to the heart of the issue, right? Let's just agree. If we're gonna agree to disagree on search terms, let's go get the judge to sign off on whatever approach it is, and we'll go. If we want to use technology assisted review and you oppose it, or you want different kind of validation than we're willing to give you, then let's just go. This isn't an emotional battle that we have to have. I was involved with the Flint water matter, right? In the Flint water matter, there were a lot of emotional issues. We were actually helping to make up for a big, huge mistake that happened that will affect people's lives for generations to come. And that was a battle worth fighting, but it wasn't worth fighting on whether we got the governor's text or we didn't get the governor's text. That is a point of law that a judge can decide. I don't need to have, tense meet and confers with the other side's technology expert to tell me that it's not possible. Well, it is possible. Here's the technology we suggest. Let's move forward or not move forward. But we don't have to fight. We just need to get to the answer. So I'm all about putting those people aside, letting them fight back and forth, letting them have the 6-month discussion on whether we're going to agree that we're going to turn over custodians or not turn over custodians, or we're going to disclose whether we're deduplicating by custodian or globally. Fight about that until your dying days. That's fine. We'll have gone through 7 of our cases on our side.
That's an interesting viewpoint on things, and I like, especially when you're talking about something as emotionally charged, like the Flint water crisis and matters like that. But even when the stakes aren't that high, I feel like every case team feels like every one of their matters is. We take ownership of these things, and we feel that they're all that important, and so these disputes come up. You mentioned ESI protocols, which I've always looked at the ESI protocol as it's the fight up front so that you can save the fight later on down the road. But it's also an attempt to let's all just get on the same page, make sure we all understand the right terms, make sure we all understand the technology that's involved here, the challenges, and so on. Because of the fact that not everyone's on board with using a fulsome ESI protocol, oftentimes that type of education has to happen throughout the matter. You have to explain, why don't we have the governor's text message, or what tool did we use to get it? How do you take that approach, or how do you handle that burden of doing that ongoing education for both parties throughout the life of a matter?
We try and do it by that open communication. I don't know how many times I have to fight to be on my clients' meet and confer calls when they're about eDiscovery issues that they don't have an in-house eDiscovery expert or resource. I don't want to call myself an expert, but I've been around the block. I know what the issues are. I know how to issue spot, and I know how to talk through them, or at least point out what my client needs to think about. Back in the day, I can remember they used to, because I'm not an attorney, they would sit me outside the meet and confers, and then the partner would send an associate to ask me what to say when they were doing, discovery concerns. And it's kind of like that now, being on the vendor side. Your earlier question about, which side do I like better? I like being involved, and whoever's going to involve me the most is how I think I can be most beneficial. And so, I try to stay involved. I try and issue spot. I try and bring things up to our side that they can then bring up to the other side if we see issues. I mean, a low-hanging fruit one is review is taking longer than we thought, so our production is going to be delayed by a week. That's not controversial. And if you haven't delayed for, I was on vacation, so I couldn't get back to you. And then, this happened, and so I couldn't get back to you. And now we're 7 months late. That's one thing, and that I can't prevent that. But if there's a technical reason why we couldn't process data and get it out the door, that's a simple call to the other side that alleviates so much of the stress and the pain that happens.
I want to transition a little bit to some of the work that you've done with Sedona. And I think that's really fantastic. You are heavily involved in Sedona. And I'd like you to, if you can, Paul, just take a moment to talk about one, what the Sedona Conference means to you, and number two, the contributions that you have made and why that's so important to you.
The Sedona Conference is extremely important to me. I feel like I'm going down memory lane, but I was at Jones Day when Jonathan Redgrave, who is one of the founders of Sedona, worked there. And I remember him coming back from the first Sedona Conference, or what I believe is the first Sedona Conference. It might have been, you know, it was a planning session for this thing. And he came into a room where I happened to be coincidentally, and he started talking all of this exciting, galvanizing, let's move the law forward. Let's, put some meat on the bones of what is going to become eDiscovery. We didn't use eDiscovery back then. That wasn't a term that we talked about. And I just remember sitting in my chair saying, I hope I can be involved with this, because as exciting as his ideas are, they totally are lacking on the technical execution side. So I went back to my team at Jones Day and I drew a picture of a rocket. And I said, if I presented this to you and said, okay, I need this tomorrow, there's no way we could do this. We could probably learn to do it, but just because we say it's going to happen doesn't mean it's going to happen. And so when I got involved in Sedona, I got involved in the technology resource panel. And we actually have a meeting next week in Phoenix as part of the regular Sedona annual meeting. And what it is a group of users. So a couple people from defense firms, plaintiffs firms, the government, and judges that sit on this thing that is also populated by vendors, right? So we have, I think right now, 9 different service providers that attend this meeting. And what it is trying to draw that or build that bridge between the two sides. The lawyers that actually have to go in and argue and get things produced and discover how they're going to discover in the right way, in a way that's fair to their clients and fair to the case and adheres to principle 1 of the federal rules, right? But it has to all be done technically. They can't do anything without the technical end of it. And so we try to bridge that gap, and there's a huge gap. So why I'm so excited, so I'm the chairperson of this technology resource panel. We're the ones that put out the glossary, right? So we get to actually define the words that define eDiscovery. It is the most downloaded document, even more so than the Sedona Principles, which are the framework where they're trying to put the cooperation in place and try to draw a framework that you can use to do your discovery. So we're more downloaded than that. We're more downloaded than the Cooperation Proclamation, which is a document signed by hundreds of judges saying, parties, please just talk to each other, just communicate. That's all we ask. We're not going to mark you down, and we're not going to think you're not advocates for your side if you just cooperate with each other. So I'm very thrilled with what we've been able to do. And now that AI has kind of introduced itself in a broad fashion. I mean, you guys know we've been using AI for many, many, many years in the eDiscovery realm, technology assisted review, even before technology assisted review, when we were just doing manual kind of predictive coding, where we were running searches and applying coding based on whatever it was, what criteria it was. Now that AI is there, I think there's an even greater role for technologists to play in the formation of how the law is going. And we can help put the box around the playground that the lawyers need to play in as they leverage this very exciting technology.
Well, Paul, thank you for the nice segue. I was thinking about how do we transition into talking about AI, because after all, it's 2024. Who can have a podcast in the legal space without talking about AI in some form or another? So here's our required conversation about AI. But you're right. AI is such a broad umbrella. There's so much that happens underneath the umbrella of what is AI. And from AI that we saw in 2010 to what we are here, what do you think in the last, let's call it the last 2 years, is really the most exciting use of AI that you see? But I think a lot of us, we immediately think of generative AI, but even under the umbrella of generative AI, there are a dozen different things that you can do with this new form of AI application. What do you see as the most exciting thing that you're looking forward to as far as what we're doing with AI?
There's a lot of exciting stuff going on with AI. And if I had to boil it down, I think it would be to the summarization level. I'm a healthy skeptic of AI. I follow a lot of people that do the development. I follow a lot of people that are on the back end talking about AI. There was a case that I saw today about a judge who ran a mathematical formula through generative AI because the expert on one side of the parties had done that. And he just wanted to validate what the expert had done and got 3 different answers with 3 different questions on 3 different computers. It goes back to, you really have to know what AI is. One of AI's largest flaws is it can't do complicated math. So you would think a computer program should be able to do math, right? It's like a calculator. It isn't, because any kind of its source that comes from a wrong answer to a math question is just as true to it as the right answer. It has no discernment ability. And that goes across the spectrum. Anytime there's any kind of, I would say, flaw in its digested material, which is hard to have unflawed human input, you're going to get that. The iteration effect now, where AI is also sucking in its own output to learn on, is like the old ditto machines. If you remember taking tests when you were in 4th grade and you couldn't read the questions because you were the last one in class and got the last ditto and all the words were blurry and you had to raise your hand. What is this, a 4 or a 7? I don't know. I can't answer the question without those things. So we have to be very, very careful with AI. And similar to when the World Wide Web came out and everyone rushed to find the great solution of what the WWW was going to be, we've had 1,400 companies, AI companies, go out of business in the last year because they have this great idea and it just goes away. I think we're still at the very, very beginning of what it's going to be. Right now, I'm very excited about Digest because I think it reliably can digest documents for you. It can reliably digest groups of documents, but I would not rely on it to tell me what my Discovery 100,000 document corpus was about. Maybe I would do 10 documents at a time, 20 documents at a time, similar to how we do grouping with non-generative AI, right? Group the documents that you think are similar together and I'll look at them. So I don't have to look at all the timesheets, because you're right, these are all timesheets. But I do want to look at these documents that you are classifying as this. But once that classifier tries to go to too big a corpus, it gets too muddy. I'm actually making a movie, and I came up with this idea with Leah Bays at NeLI, as a matter of fact. And the movie is, ideal generative AI is like a white blob of wet paint. Right? That's your ideal. That's what you want it to be. That's the corpus you want to be working in. That's the paint you want to use to go over your black wall. Anytime any color touches it, even the smallest little color, you no longer are working in a pure world. And so now you have a little dot of red in there. You're now working in a pink world. So every answer is now tainted by it. It's not like in the predictive coding world where you might have one slice of the pie be wrong because you had a bad coder and he didn't do his issue right. The disillusion of that entire set happens with one bad input. And so we just have to be careful. We just have to vet it in a way, and we have to come up with ways to validate it that we don't have yet.
There's so much to unpack what you just
Sorry.
said, Paul. So first of all, let me go backwards a little bit. For the younger generation that are listening to this, I highly encourage you to go on to Wikipedia and look up a ditto machine.
Sorry.
No, don't be. I had flashbacks that were uncomfortable at best when you talked about that, and of seeing the ditto machine crank. It reminds me also of not many people realize that a Bates stamper was a real stamper, and it was named after Edwin G. Bates, and it was patented in the late 1800s, just to give everybody an idea. Another thing is, if you are looking to actually put together that movie with Leah, my son is a film major, so for sure reach out to my son on that one. In any event, let's go.
Now.
Yeah, write that down. Let's go back, Paul, though, to what you were talking about, though, with respect to some of the highlights of what we could do with Gen AI. What I think we're going to start heading into it, and you tell me, Paul, I'm seeing flashbacks of 2012 and 2014 with predictive coding, technology assisted review, whatever you want to call it, in which all of a sudden there was discovery motions about show me what your algorithm is and how you did your tar. What did you tell the machine? And are we going to head to a place now where it's with Gen AI? What was the prompt that you gave it in the eDiscovery review platform such that it gave you this batch, and it said this batch was responsive? And so if we start arguing motions about show me what your prompts were to get to this responsive batch, when are we ever going to actually argue the substantive issues of law. I mean, do you see Paul going there, or is that me being too melodramatic and history repeating itself?
No, I think you're a great predictor of what is to come. I have such a different approach. If you can show me that you validated whatever process you're using, you could have kindergartners decide what you want to produce and not. If you can validate it and prove to me that it's a good process, I really don't care how it was created. I really don't care what went into the black box in quotes. There's not anyone that I've ever seen in any legal case. Well, I'm going to stop saying that because I don't want to be too melodramatic on my own side. There are probably 1% of judges that will take the time to understand what happens in a generative AI model, how it's created, how it's, fed, how it's maintained, how it's designed to take a prompt and execute the predictive response that it has. They just won't pay attention. Then they won't understand if we got so far into the weeds to prove ourselves right. And they shouldn't have to. It's not the law. They should worry about the law. But if I can come to a judge and say, yes, we use this generative AI to help us find documents, and this is how we made sure it was working correctly. We looked at what it didn't find. We looked at the topics. We reviewed a sample of documents that no one ever saw before to make sure that we had focused the engine the right way, and we found no anomalies, nothing wrong, nothing responsive in the pool that we didn't bring forward. There's not a judge in the world that's going to say, okay, well, that proves it. If there's nothing wrong with your process, if there's no missing information that you're obligated to turn over, then why would I question what you did in the beginning? It's like me getting in front of a judge and saying, Judge, I think the other side sped on the way to court, and they have Corvettes, and I just think that on the way here, papers flew out of their back seat because they had the top down, and the other side said, well, our top doesn't go down. Now I have to prove to the judge what kind of car they have and that this top doesn't go down, or the information I can get from the computer inside the car said the top was up when they drove 900 miles an hour to court. No, that is so outside of the realm of what a judge needs to worry about, in my opinion.
No, I love that answer. Actually, I love all your answers on Gen AI so far. And so I'm going to ask you another one on Gen AI, because that last answer starts to bleed between sort of the technical acumen and technical requirements of using generative AI. But in the legal context, we also have ethical requirements on what we understand about technology, how we can explain it to a judge. So when you're talking about a judge is going to take the time to evaluate this, but sometimes a judge may test it out back in his or her chambers by feeding something into Gen AI on their own. What do you see at this point in time to be the real ethical considerations around the use of Gen AI, whether it's for summarization, whether people are going whole hog and trying to have it code data sets for them, whether they're using it for research? What are the new ways in which we are seeing different types of ethical tripwires in discovery based on this new technology?
Yeah, I think it goes back to validation. And I also, the CEO of Everlaw did a presentation when they released or widely released their AI tool. And he said it exactly kind of how I'm thinking about it. He said, if you treat your Gen AI tool, no matter who makes it, as if it were a 1L, a first-year law student, and you check the things they do, and you can rely on it as being, thoughtful in what they tried to do, but then you verify what they did, then you probably won't go wrong. And I think that's the exact right answer. It is a learning algorithm that's doing its best, but can only do as good as what you've given it. And you don't know what it's been given, so you have to double check and recheck what's happening with it. I think that judges will insist that either the lawyers or their representatives, and I say that because you don't have to be the expert sitting in front of the judge. You just have to have access to the expert. People like me are happy to go in and explain for you. Ethically, that's all you need. You don't need to know it yourself. You don't have to be worried that you're never going to understand Gen AI. You just have to have the resource that does, that can explain it on your behalf. And so I think that judges just want a thoughtful approach. All of the judges I speak to, and thankfully, because of my experience and just the road I've gone, I get to speak with a lot of judges, and I get to speak to a lot of judges informally. And they're very excited about anything that's going to make the discovery burden less on all the parties, right? They don't want cases any more stuck in discovery than we do. They want the cases on the merits in front of them that they can decide and get through their docket quickly. And they're very excited about the possibilities, but they're also very wary because they see people just shortcutting what their obligation should be to vetting what they're doing. So I mentioned that the Sedona Technology Resource Panel meeting that's happening on Wednesday in Phoenix. And a huge part of what we're going to be working on this time is a validation paper. So from scratch, we're going to do a validation paper on how to validate different processes. It's going to be how to validate keyword searching, how to validate technology assisted review, and how to validate AI. And not like, it's not going to be a primer, but it's going to be, these are the things you should be thinking about, and these are the things you should implement into your workflow. We won't tell you what scores are necessary or things to that granular level, because that's up to you. And in one case where it might be a certain score, in another case that might be way too unobtainable because of the source data. But the validation, I think judges will very much rely on the validation to bolster the ethical responsibilities of any lawyer in front of them arguing for the adequacy of all of their searches, right? If you can't tell a judge, you know, we're pretty sure we got all of the paper that we needed to get and we never went to the warehouse out in the middle of Alabama because it was too far and the burden was too great to send 4 associates there. The judge is just not going to believe that that satisfied your ethical obligation for a due diligence search.
I'm going to look forward to, as I know Brandon will as well, that paper, Paul. It sounds interesting, and you know, a good reminder to everybody listening that some of the things that you're talking about, Paul, regarding ethics, obviously referring to the model rules of professional responsibility. Obviously, Rule 1, talking about competency requirement, Comment 8 that everybody knows has been revised to include the fact that we have to be aware and knowledgeable of the relevant risks and benefits of new technologies. Also, it's worthy of saying that to be very careful utilizing any sort of generative AI to put client information in there. You may potentially pierce the attorney-client privilege doctrine. That's Rule 1.6c. And then what you had just mentioned, actually, it was interesting, Paul, about the validation process and also making sure that it's right. It goes back to Rule 5.3b, and here we're treating Gen AI as a non-lawyer. The analogies you gave about, you know, look at it as from a 1L perspective, you're going to validate the work of a 1L. It makes me think, and here's my question for you, Paul. When we are talking about all these various different new technologies, is if there's anything that I got out of this conversation so far, it really sounds to me like it doesn't matter how advanced the technology is or what new trinket it is out there. It's all about, 1, the process, and 2, how do you validate? Am I summarizing basically what you're saying, Paul, correctly?
Yes, 100% you are. 100% you are. Technologies will come and they'll come faster and faster. I think Gen AI is one of the aspects of Gen AI that's most exciting, is that it can help us learn what we don't know and focus our attention on things that we can do better going forward. It might not have the answers. It might not be able to do a black and white, you know, here is my motion to compel, because it you know, has its issues with the fine tuning of what is absolute and what's not absolute, but it gets us to the ballpark of what we can do. And it helps us to develop the solution, which is, I think, most exciting, right? I mean, as a independent person out of the legal world, you now can use Gen AI to help you program an app and release it within a couple weeks on the iPhone. And that's all up to your brain coming up with the idea and then tweaking the system. It's a similar thing. I'm sorry, long-winded way of saying, yes, you're exactly right. If we can validate whatever it is, because the tools will always change, and they'll always change not for the better. You know, we do go backwards every once in a while. A certain mistake will happen, and all of a sudden we can no longer use predictive coding. We have to use some other system for a while the judges reel from the latest, you know, inexperienced person presenting a whole bunch of stuff that gets through some loophole, right? So regardless of what it is, if you can validate what you have done, then you're all good. It's starts from the very days of keywords, where I would have teams coming to me saying, I can't imagine I can come up with all the right keywords, come up with all the right things to pull all of the important information. And it's that fine line that we're on now. We've created so much data, there's no possible way to look at everything. There's no possible way to see everything, to find every document. So we have to do our best. And our best, in some cases, using keywords, will be come up with a list of words that you think are going to be good for pulling what you want. But you can test it. It's so easy to test. because you know there is a knowable set of stuff you're not looking at. And there is a tried and true statistical way of seeing if that contains any of the information that you find important to take forward, regardless of how you got to your reviewable set, right? The set of data that's made it up to the lawyers for physical review. There's always going to be a set of data that hasn't. And that data is always sampleable. We have so many people say to us, we can't pay to index everything. I'm not asking you to pay for indexing everything, right? If you have a lawsuit against the federal government, they're not going to look at all 752,000 employees' email boxes. But if you have 50 custodians, it's very easy to sample 5 of those custodians and look at their entire email box and the data that didn't move forward. And it's a lot less burdensome. And it puts everyone's mind at ease. It puts both parties at ease that they've come to the right solution. And it puts the judge at ease. You've done this in a way that makes sense. It's scientific, and it actually accounts for human error, which now we'll have Gen I error, but
Well, Paul, we've talked about a number of different things. You've given us some great insights, but it'd be remiss of us not to ask you about the primary reason why we're all together today, which is NeLI. And to talk about the NeLI conference and Repario's involvement with NeLI, I just want to get some thoughts from you on NeLI, how you feel about it, the reason why Repario sees it as a conference that's worth sponsoring.
Yeah, I've done a lot of conferences, and I don't know if I've done too many conferences, but I've done a lot of conferences. And NeLI was a breath of fresh air. It felt a lot like a working group at Sedona because it felt a lot less partisan. It felt a lot less directed to a point of view. It felt more like a discussion. I think having it at the college was amazing. I think putting people in that environment refires things in their brain that haven't been fired, some of our cases, for 30 years. Because it puts you in that learning. It puts you in that open point of view or mind frame so that you can really listen and hear and understand things or see different points of view. One of the discussions, that I had there was about hyperlinked attachments. And that's a huge controversial issue in our world right now. What's possible, what's not possible, what should be done, what shouldn't be done, the obligations of the party, whether documents should be considered, in context or by the 4 corners. I mean, there's a lot to talk about. We could probably talk about that for the next 2 hours and still not scratch the surface. But on the other side of the argument that I have, which is typically a more plaintiff-centered argument on this topic, there were defense lawyers saying, I totally agree with you. I agree that we should be working towards a solution and that the solution is much closer than it appears by some of the rhetoric that's going on or some of the filings that happen, and so at the NeLI conference, I had an opportunity to really communicate and exchange ideas with people of different perspectives that, moved my perspective, which you just don't see a lot in our world anymore. We're a very divided world that has their own entrenched sides, and being at NeLI it was truly a breath of fresh air because you could just meet with different people, talk to different people, get their unvarnished views in a safe environment. It just was perfect. I mean, so excited that Repario could take part in it. It was our first year sponsoring. I mean, we're only a 2-year-old company, so it's not like we sat on the sidelines for a while. We were very, very thrilled to take part in it. I hope it's something that we'll keep doing going forward. I actually spoke at NeLI during COVID, and I was very sad not to be in the room because it just is such a vibrant, active community, and happy to be involved.
Well, that's certainly why Brandon and I love it as well, and it's why we do this podcast for NeLI, in addition to our day jobs as well. Paul, can you please share with us how people would get a hold of you as well as Repario?
Sure. So you can just email me at my email address. It's paul, PAUL.McVoy, MCVOY, @Repario, REPARIO, data.com. It does sound a lot like Harry Potter. It kind of is like Harry Potter. I'm a Harry Potter fan, sorry. And you can also call me on my cell, 203-535-2647.
That's great, Paul. Thank you so much for joining us today. We really appreciate your insights. As Brandon noted, were truly invaluable. Thank you again.
Thank you.
Thanks so much.
If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in eDiscovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of eDiscovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.